Okay, here's Jeffrey Michael Watne's court orders. So in this police report, the complaint talks about he was always wiping up his daughter with a wet cloth. That's Jeffrey Michael Watne, literally cleaning up the mess that he left on his own daughter after he was abusing her, cleaning her up with a wet rag. Talks about him kissing her down there and licking her down there. At first tries to deny everything. He further stated, I might have been contact between his face and the known juveniles, females, vaginal area probably 3 or 4 times. Goes on denying touching the known juvenile females' genital areas with a massager or with his mouth. The defendant also denies touching the known juvenile female's genitals area with a washcloth. But stated that there might have been some contact while he was drying her off with a towel, but never any slow fondling. The defendant then stated that on one occasion his finger had gone inside her labia, exposing the pink interior of her vaginal opening. The defendant explained that a quick feeling thought had popped into his head. You know, when asked further about oral contact, the defendant stated that he didn't remember kissing. He did not remember kissing the known juvenile female's genital area. And then indicated that he had kissed her from time to time, and you know, it might have been right there or next. You know what I mean. Here's Jeffrey Michael Watne's plea agreement. May 21st, 2004. My daughter just turned 1 year old when he wound up pleading guilty. Sexual contact in the second degree. Committed on or about January 1st, 2002. And on to 2003. Generally recommended conditions of sentence or stay. A cap of 1 year local incarceration. Sex offender evaluation and follow all treatment recommendations. Non-prison disposition. Molesting his own daughter for over a year. 3 counts criminal sexual conduct. Each count carries a minimum of 96 months in prison. He gets a 1 year stay. No prison. Gets work release. Gets a leave stayed on work release. Here he is writing a letter to the judge. Judge Mary Threeson is the judge that took the case, sentenced him, and closed it all on the same day. He goes on crying and complaining about that he got work release, but he's not eligible to keep his job, apparently, due to him having to cross state lines due to his work, and his job would not be able to keep him unless he was able to do it a few times a week crossing to Wisconsin. Part of the policy of being on work release is you cannot leave state while on work release, so he would not have been eligible for it. But by writing a letter like this to a judge, Judge Mary J. Threeson allows him to do it anyways. My employer cannot keep me if I cannot make deliveries for him. Will you please help me? My truck is tracked via a GPS system. my whereabouts. Yeah, yada yada yada. I hope all is going well for you, and thank you for your time and consideration. Unknowing to me about this guy and his legal dilemma here, but during this whole time, this guy's been around my own minor child. This is a guy that my ex wound up dating, and she was aware of all this, knew about his situation, and still hid it from me. Dakota County Courts, probation, so on and so forth, intentionally hid it. This shit's sickening. Yeah, I'm going to treatment. All is going well. I've taken responsibility for my crimes. And you're not supposed to be around kids, but you were around my kid? You ain't taking no responsibility. And under the circumstances, things are going well. Shortly after I got here, got approved for work release. But mommy, yeah, I consider this, calling this Mary J. Threeson his mommy, which isn't probably legal his mommy, but this is almost like a letter you'd write to your mommy. This is where I need your help. I have an outstanding work record. Yeah, but you don't have an outstanding record of being a father and being around kids. Other than my crimes, I have lived responsible. I don't know about all this. I desperately want to keep my job. My kids are depending on me for support. And I am responsible for paying for my treatment. I am trying to rebuild my life, and without my job. Wow. I desperately want to keep my job. Did you ask your daughter, does she desperately want you touching her? My kids are depending on me. Were your kids depending on you molesting them? And you find it hard that you're responsible to pay for your pedophile treatment? Fucking disturbing. Writes a letter to his mommy, which I call it, Mary J. Threeson. She actually writes him a letter back. Tells him exactly what to do and how to do it. It's improper to contact ex parte. I am required to hear from both sides in the matter on these. Never ever have I ever had any type of consideration letter like this from any judge dealing with my issue or problem. Ever. And how many times I went back to court and filings and went to court on stuff like, and to find out this dude's molesting his own kid for over a year, and this is the kind of treatment that he gets from a judge. Sends him a letter back and tells him exactly what to do and how to do it, and if that don't work and you don't have an attorney here, tells him exactly what to do and how to do it and how to take care of his problem and situation, and giving him legal advice. Never ever have I ever had any type of courtesy period on any type of legal advice or any type of advice from any judge going through any of my situation. And this guy's got the straight up lowdown like it's goddamn legal aid to him. This judge just wound up said, I'll just put it through, and if there's a problem with it from the state, the state can object to it, and then you might have to file papers and get a court date and take it in front of a judge, and of course it would be in front of her, and they went and did all that, and of course she just signed it anyways, regardless of what the state said about the county attorney, and regardless of what they disagreed on, and the judge ordered it anyways and pushed it through anyways. I am receiving your 2003 letter. I will approve your client's request that he be permitted to travel to Wisconsin as necessary for work. So his attorney just wound up sending a letter to the judge then, and the judge winds up approving it. Presuming Mr. Holback agrees, if I do not hear any objection by the end of this week, consider your request granted. If Mr. Holback does object, then this matter should be scheduled for a hearing before a judge. I will copy this letter to the jail so that they know that I have approved your request, unless they hear from me to the contrary. She was already approving it and sending a letter straight down to the jail, allowing it, pushing it through, regardless if she even heard back yet, even from the county attorney's office yet, whether they're going to approve it or not approve it. She was already sending a letter to the jail, approving it and allowing it and letting it go through. A convicted child molester, this is the treatment a convicted child molester fucking gets. And yes, like I said, Scott County Attorney's Office did object to allowing it. The state does object to Mr. Watne being allowed to travel outside the state of Minnesota. He is currently serving a 1-year jail sentence under a stay of imposition. The guideline sentence is 90 months to the Department of Corrections. He not only receives a non-prison commitment, he received it under a stay of imposition rather than a stay of execution. Your sentence states that he's entitled to work release if he is eligible. If he is not eligible, pursue to the guidelines of the jail to travel outside of state for work release, he should not be allowed. Jail should have some inconvenience for the person convicted of the crime. A fucking child molester. This is a treatment a convicted child molester was getting. A convicted child molester was molesting his own kid for over a year. May travel to Wisconsin as necessary for work only. This guy hasn't even taken any responsibility for his crime at all. This is where he finally actually had to go and sit in jail from being charged, from the time his ex-wife called the cops and reported all this, and then for him to get a warrant and actually be charged by the courts. He just got a summons in the mail saying he had to appear for court, that he was being charged. They gave him a bail of his own recognizance. No money, just on his own. And he had to just show up for court for the next court date until he wound up pleading guilty and getting sentenced, and that's when he actually was thrown in jail. complete a sexual evaluation and complete aftercare as recommended, register as a sex offender, keep current, no unsupervised contact with children under the age of 16 except as set up with treatment or through therapist services to have time with own children. Successfully complete Alpha program and all aftercare, and sign releases. If failed treatment, to prison, 90 months. May 20th, 2004. My daughter was only a year and 2 days old. A year and 2 days. May 18th was my daughter's birthday. My daughter was technically only a year old at this time when he got sentenced. And he was already around my daughter. Here's another one. The defendant is released upon the following conditions: on personal recognizance, keep all court appearances, do not leave the state of Minnesota without court approval, report to jail and complete a booking procedure, no contact with victim unless with supervise, which has been set up with mom. And that was September of 2003. Now March of 2005 is when he gets done whatever and transfers his probation over to Dakota County. March of 2005 now. Now my daughter's almost 2 years old. (2008) The defendant's sentence and conditions of probation be amended to allow unsupervised contact with his juvenile son and with the juvenile daughter of his girlfriend, which is my daughter. Actually filed court papers in Scott County to try to amend his conditions of no contact with minors, trying to get approval from a court in Scott County to have unsupervised contact with my daughter. At this point, my daughter's 5 years old. A convicted child molester is filing papers in Scott County on my daughter to trying to get unsupervised contact with her. No knowledge of this whatsoever. Never was informed, contacted, told anything whatsoever about any of this. Ever. Never even knew about his crimes or what he did or him being around my kid, period. Here's what Dakota County Corrections, the probation officer, wound up sending over to Scott County. Mr. Watne has a hearing scheduled on Tuesday, May 6th, to petition the court for unsupervised contact of his girlfriend's daughter. Up to this point, Mr. Watne has had permission to have supervised contact with her. How is he getting permission to have supervised contact with my daughter when all his court orders were no unsupervised contact with any minors except for his own kids? How were they ever even approving it at this point? Our department would request that if the condition is changed, that it read no unsupervised contact per PO. Underlined, big letters. That's how they wanted it to read. They still wanted it to have no unsupervised contact per PO. Per PO's request, that means a PO's approval. At this point, it shows clearly in this letter that they never had any type of authority or approval whatsoever to allow it to be going on, to allow him to even be having supervised contact with my daughter. Not until it would have been written like this, and then it would have been approved. It was never ever written or approved for anyone to have any authority by anyone until it was changed by a court order, signed by a judge. Our department would also still want to evaluate the situation on an ongoing basis and would require that the family attend a program addressing good touch and bad touch that would provide educational to the little girl and to help evaluate how able she would be to report potential problems. And I hear about this, and this shit makes me just, I don't even want to express what it makes me feel, or I can't even go down that road. These probation officers are sending a letter over to Scott County telling them that they want my daughter to be in some kind of pedophile, touchy, talk about program. And as many times I went to court and everything I was trying to do just to see my kid locked in a room for 2 hours every other weekend, this fucking pedophile is getting treatment like this. Project Pathfinder would be a good recommendation, on one similar to it. Unsupervised contact would not be approved without support from them. It is further requested that a condition of submit to a polygraph per PO's request be added. This way, it provides us with additional ongoing information to help evaluate the potential risk of unsupervised contact. Mr. Watne recently completed one. If he wound up completing a voluntary polygraph test, they would have asked him, obviously, if he's been around minors without supervised contact, and he would have had to at least admit that he already was having unsupervised contact because he was already having it before he even got sentenced or even pled guilty. Judge Mary J. Threesen winds up ordering, after all that, Big letters. Motion to lift, no contact, is not granted. She did not write per PO's approval. Nothing whatsoever. Big letters. Made it clear. Motion to lift is not granted. May of 2008. 3 months later, Dakota County probation officers allow Jeffrey Watne and my ex to purchase in both their names a so-called duplex, which is a multi-family home in reality, which they were both living there. And they want to say they were living in separate units, that he was never around my daughter unless it was supervised. And then it went on, he was not around your daughter in their house, or my daughter was not allowed in his area. The only time he was allowed in my ex's area of her so-called duplex is only when my daughter was not there, when she was with a family member or with me. Dakota County probation officers, Terry Olson is his probation officer. When I found out about this guy, and even at that point, I did not know exactly it was his kid that he was molesting. I thought it was something to do with his ex-wife. That's why he got charged with criminal sexual conduct. At the beginning, when I found out he was charged with criminal sexual conduct and he was on probation for 25 years and he was on probation, I contacted his probation officer, Terry Olson, and she told me it wasn't a concern of hers for me to know or to be aware about it. And I said, yeah, maybe it is not to you, but you ever think maybe it is to me? Straight up told me that it was not a concern of hers, that I would be notified or be aware of it. And here the judge wrote, avoiding unsupervised contact with children under the age of 16, subject to exceptions, approval by probation. And this is the first time that it was ever written in any court order or signed by any judge, was at this point, is when it was actually written now like this. Now here's his charges and his court orders, and just January of this year is when I actually got a copy of all this, and stating that he was not even supposed to be around kids or have contact with them, period. All his court orders were no contact. And when they wound up purchasing a house, and before they did, he tried to get that changed, and the judge ordered still again in bold letters, no contact. They never had authority or approval, period. If they even, well, obviously they knew, because they already admitted that he was having contact with my daughter, supervised apparently. Apparently my ex was a certified supervised person, which he only took a 2-hour workshop through Project Pathfinder, which is only a 2-hour workshop that just only gives you like the resources, what to look out for, just kind of like, you know, what to do in, you know, a background of what to look out for in case you want to bring a family member to a picnic and there's family members there and there's kids there. That's all it is. Just to be a supervised person like that, just to watch that person while you go to a family picnic or something, or not to be living with them. Come on. And no matter what, in Dakota County own handbook, their own playbook on anything like that, anything that is a supervised person, and even if you're a certified and a licensed supervised person, you have to renew it every year. The thing would only be good for a year. Even if she took it to our little workshop and they want to claim that was legit and legal, even that would have to be renewed every year. It's in their own playbook. Their own statute, their own standards, their own guidelines.